Judiciary Committee, and we are next going to hear from Tim. Are you there? Yes, he is. Excellent. So if you can weigh in on what you've heard today, or if you haven't been here to hear things, we're kind of we're not going with what we have as far as language in the section regarding custody. That has been jettisoned, and we're looking to possibly update a definition in 33 VSA 16. No, wait a second. What is it? 5102 16B. But would welcome your comments on any of this.
Yeah, so I listened to some of it on YouTube before logging on, not all of it. Tim Leaders-Dumont, Department of State's Attorneys and Sheriffs. And you have to deal with me because Kim is out this week. So don't blame her for anything I say, because I know she's really been the lead for the department on this issue and done a great job. I wanted to start off by saying, just looking at the bill's language, thank you on a bunch of fronts for the delay. What we need to avoid is chaos on April 1st for the practitioners and for youth, for children, for law enforcement officers, for state's attorneys and judges. We need to avoid chaos. So if this is a vehicle to avoid chaos, we need to move it. If this gets bogged down, which maybe it sounds like things are getting worked out, but if it gets bogged down, we'd recommend pulling out the delay and putting it somewhere and putting it something that you can move quickly. It sounds like some of that discussion's happening. But also, right, the bill started with the raising the minimum age. I voted as a member of RDAP to do that in terms of the recommendation you originally received. So that's still good.
So can I ask a question on that real quick, Tim? We're considering removing the exception for murder for under 12. Do you have a viewpoint of that? I mean, we've heard, I think DCF suggested they were not opposed to that. And, we've heard from Marshall, who suggested whenever they've had somebody not even dealing with murder, but other kind of criminal offenses or delinquency offenses for under 12, more often than not, the person's found incompetent to stand trial anyway. So those are kind of what we've heard, which is weighing in on whether we exclude that exception. If you have a viewpoint on that, would welcome that.
So with the exclusion, because I don't have it right up in front of me, would the exclusion disallow for the filing of a delinquency?
Right. So under 12, there would be no delinquency, no exceptions.
The only thing I'll just note, I will say my Judge Zone line, I don't know if he's still in the room, but obviously this is a policy choice for you all. But I mean, if there is something that happened, there would be victims. And so if there's a chins, there's like no victim aspect for a chins. With the delinquency, there is a victim, even though it's more limited, there is victim opportunities in the chins to engage. With the chins, there really isn't, because you're filing essentially a social services directive for engagement with the parent side of things, which again, we would pursue that in a case, right, where someone was killed by someone in this age group and we didn't have the option for a delinquency. We, depending on the facts, probably file a chins for the child having the ability to do that. So just as a point of testimony on the record, if you remove the delinquency piece, which is totally in your lane, it would just mean there'd be less on the victim engagement side, which is already more limited than the criminal side, because it would be a delinquency. But I'm almost hesitant to even comment too deeply on this, just because I haven't thought about it too much. Okay. But yeah, I'd say your call. I don't see a lot of these. Obviously, I do know of one factual scenario in the last 5 years that meets this description. It's top of mind. So there were victims and they were upset in that case, just so you know.
So this is one where they were sent to Chin's proceeding instead.
I am not going to comment on the specific case. So yes, but in terms of the overall moving the age up, like in general, I was really proud to vote on that. I think there's not that many cases out there. And it was a good decision. Again, we'll do more of the chins thing if there is a need, but it's very low numbers. I remember DCF presented the numbers, it was very low. in terms of filings on that. I think I heard some of Judge Zone's comments about the custody piece. So it sounds like, I don't know how much more you need from me on that.
I think we're pretty well set unless you have an idea of how to make that work, but I don't think it's workable, is what we've heard. And I think where we are now is that, we understood from DCF and other witnesses before that DCF couldn't take custody or bring somebody 18-year-old into, the locked facility and such. But now we understand that that's not the case, that there's not a legal barrier. There's a barrier in that there's not programming or a facility is what we're hearing. But we're going to clarify presumably that in this one definition of custody for over 18 and overs. That's the current plan.
Gotcha. Okay. Yeah. Clarity is good. The position of the department is that the ability to place somebody who's over the age of 18 is not custody. It's not the same as custody, but it's a little bit of a distraction from the rest of the bill because we're talking about delinquencies. So in terms of enforcement and accountability, we don't have a place to put these folks in Vermont right now anyway. There's no place to put an 18-plus-year-old. But what we've heard is that when a person is being treated as a child in a delinquency who's over the age of 18, there's a lot of throat clearing, is in, let's say they're in custody because of your clarification, they're going to be their own guardian because they're over the age of 18. And if they don't want to go to the program right now under the current law, they can just refuse to engage with that. And unlike with the YO, because we're dealing with the delinquency, there's no mechanism to really enforce or have accountability there, which I think Lindy talked about as well. So, but our position is there isn't pure legal custody in the same way that I think you're all thinking of. So clarity is good, as Judge Zone, I think, was alluding to, whatever you all do.
So let's explore it just a little bit more then, because I continue to be confused that, well, maybe not. I mean, I guess, I keep on hearing it comes down to the fact that they don't have a guardian and can't be forced to go somewhere. But then I heard that that's a matter of, well, we heard from one individual saying that depends on the provider, but then we heard from DCF that that's not really quite the case. So is there something we can do that says if you're in the delinquency system and you're 18, that you can be involuntarily held if it's similar to under 18? I mean, that's what we've been looking for, to try to have that so-called backstop for individuals who are not following the probation or conditions.
Yeah, it's a two-parter. You need a place for them to go. Right now, we don't have a place for them to go. And then just providing clarity. Our read of that sort of convoluted commissioner can recommend placement is not, from our perspective, the same as what I think this committee is used to hearing about, which is lack of ambiguity, right? Custody is custody. And it's much more clear for the 18 under population. So the fact that there's any discussion that we're even having means that there's an opportunity for clarity, even if, and I think Attorney Paul has pointed to one perspective. I think DCF has noted, right? Yeah, maybe there's custody pathway, but if they don't engage, it's not really custody. And then the judge has said, if you're going to do custody, what does that look like? What are the limits on that custodial option? But kind of regardless, many of the other states that I think you maybe alluded to in some of your pieces have legitimate youth facilities for 18-plus-year-olds. And we don't have that. And that needs to be a priority in the next 2 years. We need to have a facility for 18-plus-year-olds, regardless of whether or not they end up there because of some future enforcement mechanism, under delinquency, whether or not they end up there because they're in the YO space. But for the 18-plus population who are being treated under Title 33, it needs to be sorted. I think the point of my testimony on this is okay to talk about the custody piece, but right now it almost may be a bit of a distraction because we're talking about delinquencies. And the point of, I think, what you're trying to do in this bill is the phase out, bumping out phase 2, and trying to get at some of these fixes, like extending the age of jurisdiction. I think thank you for including that in here. I think that's something you heard from Kim is a very consistent issue that we're dealing with. So yeah, I don't know. We could kind of live without it, I think, in this bill for now, because there's such important pieces that are in it.
That's the whole custody issue we're talking about. So again, we're really, as much as anything, trying to focus on how to deal with current 18-year-olds and setting it up for us getting a little time to see how we're dealing with 18-year-olds up until the time when we have 19-year-olds. But so far, we haven't heard really what that language is would look like, or whether it's even needed. But we are going to try to do one clarification at least, and you'll all have an opportunity to take a look at that before we vote, obviously.
Great. Yeah, I think that's really it. I won't burden you guys with much more from me. Just noting that we want to avoid, and I think you've all heard about it, just avoid any chaos on April 1. We would have to do some shuffling from a notice perspective if things are going depending on what direction they're going to do to our people out in the field.
But we've all gotten a lot of shoveling in recently, so you'd probably be good to go on that. But I meant snow, of course.
Oh.
And of course, you're no burden. And thank you very much. Unless there's other questions for Tim. Tell Kim to get back here as soon as possible, though. Okay, Tim?
Good. I will do that.
just kidding. So we'll go to Tucker next. Thanks, Tim.
Thank you all.
All right, Tucker, tell us how to fix everything.
Good morning, everyone. Tucker Jones, Department of Public Safety. Thanks for having me in on this. I have been following along this morning and appreciate where the discussion is at this point. My testimony is really not any different than from last week's testimony. I think you're kind of getting there with this bill as it relates to delay and raise the age. But I think the kind of bigger issue regarding enforcement of noncompliance with delinquency conditions of release and probation terms is still outstanding. It's an outstanding topic. And it matters this session, I think, to really solve it, because under our current regime, we are presumptively filing domestic and sexual violence cases that we've discussed previously, and some violence cases involving firearms as delinquencies for those who are 18 years old. And there is not currently a secure facility to place those youth pre-adjudication or adjudication. And that's the current state of reality. In addition to that, the feedback from the state's attorneys from last September really raised this concern about the toothlessness of delinquency conditions of release and probation conditions, and this idea that we kind of go in this circle throughout the process until eventually they age out. And that begins to matter when we have these more serious cases that really require compliance with the oversight from the court. You know, the feedback from some of the deputy state's attorneys at the time, right? If you'll recall that some of the quotes: raise the age creates barriers and delays for circumstances which do not comfortably fit in the family court due to safety and severity. The court does not have the proper resources and laws to compel 18 and 19-year-old delinquents to engage in the process. They have not done the legislative work necessary to make this a reality. And I don't think it's just an issue of operational, facility access and programming. I think it's in part kind of lack of clarity over how to meaningfully enforce violations of the conditions of release for these serious cases when they are 18 or over. So that's outstanding in this bill. It hasn't kind of been addressed fully yet. And I think that attempt for clarity on custodial authority may be helpful to provide some greater clarity. But since there's really no location yet for those 18 and over, it's in a way almost a moot point, because you add all the clarity of the world, we don't have a placement. And this distinction on legal and physical custody, I do think there's an opportunity for greater clarity there, because in these more serious cases, you do really need the sub-level of authority, I think, for DCF to kind of require certain services for these youth, to make sure that they actually are meaningfully rehabilitated. And it doesn't seem to me, based on the testimony this morning, that is really happening. That we're really ensuring that they get the treatment or services when they're in that age category. Anyway, so that's where I think it stands right now. This is part of this bigger issue of why we're raising the issue of these more serious offenses, because non-compliance starts to matter a lot when you have, whatever it is of these more serious listed offenses of the other related offenses, and you really have a toothless kind of system that doesn't meaningfully or quickly, provide some level of recourse. Anyway, so it's going in the right direction in the sense that you have to raise the age delay, but I don't think this particular bill is responsive to those bigger concerns about meaningful enforcement.
I appreciate that, and certainly been trying to push all witnesses and ourselves to try to address that and keep on hitting our heads against the wall on how to do that. And I don't think the answer is that we can send more people who are 18 or 19 to criminal court, and that may be where there's a difference of opinion. But so, and we're open, and I guess we continue to be very open to other ideas of how to make that work better, and we can continue that discussion. But probably, as you're saying, it will probably not be in this bill because that's going to take more time.
Yeah, I think so. I mean, look, I understand. I raised this earlier in January about at what point should some of these offenses not be initiated in the family division as delinquencies, and I understand that pushback on that from the committee on that proposal. But a slightly different approach is, at what point does a violation of a condition of release or a violation of probation warrant a kind of conversion of that probation violation itself as a criminal probation violation, or that VCR, that violation of condition of release, as a criminal VCR, not to restart the underlying case in the criminal division, which is the issue that was pointed out there at the last scheme that you had for probation violations, but a criminal proceeding for the violation itself.
Right.
And so that type, there's, I think, a path forward for that type of meaningful enforcement authority. So at a minimum, the young person can be informed that that's a serious risk associated with not complying with the terms, as some way to kind of garner compliance.
So do you have any draft language that would accomplish that we could look at?
I don't have it right now, but I don't think it would be particularly complicated to, draft up. So that's something I could work on potentially.
All right. So we can see if we have a vehicle for something like that. If it's going to take longer, that would be fine. But I think that's worth looking at. I think that's definitely worth looking at.
And the issue with the probation violation scheme you had, it wasn't a bad scheme per se. It was just this idea of reinitiating the underlying case all over again in the criminal division. Wasn't kind of the right remedy. It's not a remedy that's really makes sense or is available. But
right.
Some other type of remedy where there's a real serious risk that the case basically gets transferred out of delinquency proceedings, or there's a separate risk of a VCR or a VOP in the criminal division, I I don't know. There's some path forward, I think, in that direction.
Yeah, could be. All right, appreciate that. Um, anything else on the bill?
No, nothing else. Thanks for having me, and I appreciate it.
All right, thank you for your testimony. Appreciate it. All right, so we will be, hopefully this was the penultimate version of this bill, and we'll another one sometime soon. We'll try to, yeah, I think the intent, I'd like to have this voted out before we head out for break. We're not dealing with this last week before question. So Bob Paolini, look at that, 11:30, right on the nose. We only had to move you 2 or 3 times to get it right. It's fine. I appreciate you your flexibility and being able to do that.
Thank you for having me.
And this is probably, do we have, Nate, the proposal on today, or is it yesterday's? Probably on yesterday, right? Which is fine, if it's, because you submitted a proposal or what?
I did at the beginning of the week, but I gave Nate something this morning.
Oh, okay.
I just got, it's something different, but I got it from I'll start.
Okay, great, thank you.
Bob Paolini, Executive Director of the Vermont Bar Association. Nice to meet you. I know most of these other folks. I know all of them. Yes, Representative Millay. But thank you for taking the time both yesterday and setting aside some time this morning to talk about access to justice on the civil side of the courtroom. The testimony you heard yesterday contains pretty much everything I think you need to know. And it really gave you a good picture of what the system is like. I'm not here because the Bar Association is asking for any funding. I doubt that we would apply for anything. I'm just here as one of the members of the coalition, try to bring this all together. Yesterday, you asked a question about the Poverty Law Fellow. I just wanted to clarify that that was a program that the coalition started in 2007 or 2008. But that's funded not by IOLTA. That's funded by our contributions. We do a fundraising campaign every year that members of the bar contribute to, and that's what funds the Poverty Law Fellow. We started back with Grace Pasdan in 2008-9 on mortgage foreclosures during that period. And then you met Jill Diaz yesterday, or maybe you've already known her. She did some work. Last year, we had an immigration person work for 2 years. And now Deanna is working on homelessness issues. The proposal is, it's meant to go part of the way towards solving the problems that you heard about yesterday. Specifically, we're asking that this committee, we've asked this before, recommend to the House Appropriations Committee that there be a grant to the Bar Foundation in the amount of $525,000. 500,000 of which would be funds that they could grant, and then there's a 5% administrative fee payable to the foundation. Representative Dolan asked a question yesterday about why don't these agencies just go to appropriations themselves? And if you look at the document that Nate posted just an hour or so ago, you'll see that there are, and this is dated, this is 22-23. These are a list of grants made during that time. This is what Hannah gave me about an hour and a half ago. There are a dozen or more grants, and they're very small, 4,000, 5,000, 5,000, 4,200. But they range in different types of work in different areas of the state. You may, if you get the Chief Justice in to talk to you, I think he'll talk to you about what he's now calling legal deserts, parts of the state that are not manned really and are underrepresented by lawyers. I would expand that to say, not only are there no lawyers servicing those areas, but if there are not people that do certain kinds of work. And you heard some of that yesterday. You heard some of the problems that we have in family court. trying to get lawyers to represent self-represented litigants in family court. Very difficult to do that. The consumer debt issues, defendants in either small claims or in the superior civil division are generally not represented. People with disabilities, very often not represented. Victims of crime, very often not represented. We get a small grant from the Center for Crime Victim Services through VOCA, Victims of Crime Act. We're not certain how long that's going to last. We're actually in the middle. Right now, we're not taking new cases or making new assignments because of the freeze on spending. We don't know where that's going to end up. We think that the Bar Foundation, and I think Hannah King said it well yesterday, they have a robust grants committee. They know the systems, they know the state, they know where the needs are, and they can make grants that are targeted in certain areas of the state and in certain areas of need in terms of the substantive need. I think better than most can. So that's it. I mean, we had this conversation with you last April or May. It was very late. You agreed at that point, and you did put something in a letter to the Appropriations Committee, passed the House, I believe, but it did not get taken up across the hall. So we're going to ask that you consider doing that again. That's really all I wanted to say. I don't want to stand between you and your lunch, so I should be brief.
I have one question. It was a little confusing for me yesterday with all the different players that were in here. And I'm just wondering if everybody is kind of under one umbrella and who holds the umbrella?
The reason the coalition exists is so that we can coordinate with those bigger agencies. But there was two bigger agencies here yesterday, Legal Services and Vermont Legal Aid. And the last thing we want is for these dozen or so littler, smaller agencies to be in some kind of arms race against the big guys. So we wanted to do this together. I don't know that if this happens and the foundation gets this grant, I don't know who they're going to fund. They may not fund anybody you heard from yesterday. They may fund News Story Center in Rockland County, the Pride Center, the Community Restorative Justice Center in Caledonia and Essex counties. I don't know what they would do. I'm not on the grants commission, but I think we can fill those needs. I mean, I hope that the big providers get all the funding that they need. And I'm sure legal aid will appear at the Appropriations Committee and make their annual request for their budget, as they should, just as the Judiciary does. What we're trying to do is to get assistance to people around the state in other areas that the big guys right now aren't serving. Now, $500,000 is a lot of money, but in a what, $8 or $9 billion budget, maybe it's not a lot of money. Is it going to solve the problem you heard yesterday? No, it's not going to totally solve the problem. It's going to help. It's going to help.
Yes, thank you for this overview, and I appreciate seeing the different grants that have gone out with it. And I remember last year we supported this, and I think my take on it, like, yes, this sounds great. I feel like I am up for supporting it, recommending it again. And then our House Appropriations Committee takes in the big picture of, does this fit? And if so, then we can move it forward. My question is about the Senate, because it didn't make it through the other body. Was there any feedback or anything that they shared that is addressed in this proposal, or is it just submitting the exact same proposal and we're just hoping the other body will move it forward this time?
The group that was here yesterday and myself did testify at your counterpart, the Senate Judiciary Committee. There really wasn't any pushback. last year, this proposal was tied up in a bill that had some tax implications. And that bill went to Senate Judiciary, and they didn't move it at all. I think we were with, we were in the wrong company last year to get much attention. I thought we had a very good reception at the Senate Judiciary Committee 2 weeks ago. So I think we might be in a different posture this year. At least I'm hoping so.
Are there other, I don't think, Bob, this is a question for you, unless you have thoughts on it. Are there other areas where the state sort of grants money out to a subsidiary and then subsidiary makes conditions for then doling out those monies?
Well, I think the network does, for instance.
Okay.
Comes through here. You know, they send out money to their membership organizations.
And they get to decide
And
what.
DSAS gets to decide which state's attorneys get the.
Yeah, so.
Yeah.
And this is who is on the subcommittee for the grant?
The foundation?
Yeah.
I don't have that list. I could get that from Hannah. I'm not sure who is on the committee. The Bar Association has representatives on the foundation board,
Yeah.
but if any of those are on the grants committee, I don't know the answer.
Do you know how big it is? How big the grants committee is?
Don't, actually, I don't. And I'm sorry that this is 22, 23. I had asked Hannah for something just, last minute this morning, and this is what she was able to get.
This is an idea. Sure. Any other questions? I appreciate your time.
Thank you again for having me.
So before we break, I would like to just have a little bit about 105, which we heard yesterday. Can't find my 105. It's here somewhere. That was the what's the
Youth Substance Awareness Safety Program.
Yeah, the Youth Substance Awareness Safety Program. The big question I have, well, are folks interested in moving this along? It's kind of one question. I felt that seemed to be the case yesterday. There wasn't a lot of opposition to this. But the other is whether to have, so as I understand it, and correct me if I'm wrong, if people know this probably better than I do, that currently individuals who are driving the 0.02 population get a ticket, $47 and 6 months suspension, but they can go to this program to avoid that? Is that, or is it optional?
Am I the expert?
Yeah, you're the expert on this.
Oh, boy. I don't know.
Okay. So,
So much for.
so
My understanding from the testimony yesterday was there were basically three things that could happen, and you could have any of the three. You could get a DUI charge, you could get the referral to the restorative justice, whatever, diversion, thank you. And if you failed the diversion, you would have a 30-day suspension. And then you also could get this $47 fine with a 6-month suspension on the civil.
30-day suspension on your license?
If you didn't successfully complete the diversion.
What if you're 14?
you got other bigger problems.
That's at least, Karen, does that track with?
Oh, I don't know.
I don't know. That was kind of how I understood it, that there were all three of them, but.
Yeah, that's how.
You lost me with the second proposal there was what?
So I'm not an expert.
No, I get it.
Yeah, I thought what I heard was basically there was an option for you to basically go to diversion.
Right.
And if you fail to successfully complete the diversion, then there was a 30-day suspension of your license as an element and a fine.
And the diversion
That's all.
program.
But it goes, I mean, you just don't fail diversion and lose your license for 30 days.
Yeah, it was like if you didn't, they were like, I think they said something, I think the testimony was like, yeah, we like, if we contacted you and you never came back, you never contacted us back, or like you failed to, yeah, and then you would get this other penalty, which was the 30-day suspension and fine. I think.
$47.
No, that's the third thing, which was the,
So what was the fine?
I can't, I don't know, I actually don't know if we got testimony, if what the fine was, I'm not sure.
This is on the driving while intoxicated, the 0.02 ticket piece of it.
I don't think,
Yeah.
I don't think they have, they can get, I'm looking at, 7 VSA 656.
Yeah.
Which is prohibited conduct of a person 16 years of age or older and under 21 years of age. It's falsely representing the age for purpose of procuring or getting beverages, possessing, consuming, and it doesn't have anything about, the, O2.
We'd
If
be
you go
adding
to-
that.
Right. And if you go to 657A, that's a person under 16 years of misrepresenting age or procuring or possessing alcohol beverages delinquency. They can be delinquent, but they can also go to court diversion. So that's where that comes in. That's, again, not a 0.02. The 0.02 is in 23 VSA 1216. And find it. And that doesn't have that as an option, doesn't have the diversion as an option.
Yeah.
So it says to me that if you get a 0.02, you don't have diversion as an option right now. And this is all leading up to the question I have, but I wanted to say it's now first.
And that was my understanding too, was that the diversion was not an option for the 0.02. And, but that the inconsistency was that depending on who you got pulled over by and where you were,
They might not give you a 0.02.
Might not get a 0.02 ticket.
Well, it's just a civil ticket. It's not a criminal anything.
yes,
0.02 ticket.
yeah.
So here's the question that I have for folks, now that we got that out of the way. The bottom line, 0.02 doesn't have diversion option. It will give you, you will have a 6-month, if you get the 0.02 ticket, you're gonna have a 6-month suspension. The question is that if we now have a diversion option, should we still have some sort of suspension of the driver's license? And I think we should. I know that we've had some discussion. I mean, I think that that's pretty serious behavior, and I understand where Marco's coming from as far as punitive versus safety, but losing your license when you're 16, 17, is a pretty good consequence, it seems, if you've actually been driving after drinking. So I just wanted to get the sense of where other people were adding something like that.
How long do you lose your license if you're 21?
So
Well,
it's
that's-
90 days. And there's depending on where you are in the DUI structure, it could be a 30-day hard suspension, meaning you can't get the interlock. But depending on where you are, it doesn't mean, but they're 90 days.
So
For DUI.
use it's a different penalty as far as losing your license goes, potentially.
Right, but putting it
Which
in.
I don't have an issue with because I think it would register more than.
Right, but the option right now, the way this 105 is written, is they could go into diversion, would have no suspension unless they failed in the diversion. And what I'm posing, and I don't know exactly what it would look like, is that there'd have to be some suspension as well. You're grounded from driving that car for.
If I'm 16 years old and I don't get a suspension and I go to diversion, I'm high-fiving my friend.
Yeah. Right.
Yeah, that perfectly put.
I would like, if we're gonna do this, to propose the 10-day
Well, I
diversion.
think that's the next question.
Yeah, okay.
But Tom first and then
Okay.
Becky and.
I checked with him again. He got back to me rattling. I was correct. If you're a juvenile and you have a moving violation ticket, it's a 90-day suspension if you're on a learner's permit. So, or not a learner's permit, a graduated license.
Right.
So, I mean, to get a DUI and not get a 90-day suspension, that's pretty.
So, but we have to balance that with the wanting the carrot for going to diversion, which is a better path. So it's like.
Diversion is
so-
90 or 6.
Well, that could be it.
Just
It
an
could be-
idea.
It could be diversion 9 or 6 months. It could be.
Are we talking about an O2 or higher?
O2, well, an O2 or above, it's O2 between O2 and O8, right? So an O2 ticket, which my understanding, that doesn't mean it's just 0.02.
Well, they could be also charged with, not a DUI, but just impairment.
Yeah, no.
And so that would be criminal as well. I mean, so you got the parallels.
Putting that aside, it's just for the .02 situation. Do we have them lose their license during the period that they're in diversion? And if they fail in diversion, they get tacked on? Do we do like you say, even 90 days, but if you don't do diversion, it's 180 days? You know, there's different.
Yeah, I think you need at least 90 days if a moving violation is 90.
Yeah.
DUI is a lot more serious
90.
potentially than a moving violation.
I would not agree. I'll let Ian go.
So, yeah, but there's not in the moving line violation, you're not going to diversion to try to modify the behavior. And we're
But
trying
the
to
DUI
balance the,
is more serious.
no, I understand, but we're also still trying to have. Yeah, no, I understand, but we're trying to channel them into a program that has better longer term outcomes as well. Where we're not doing that for the moving violation. So I'm trying to find that balance. I agree that we need to have, you know, some period of suspension. But yeah, Ian, you were gonna.
Well, my thought would be have the suspension be immediate and have it be in effect for the length of the diversion. And if you successfully complete diversion, then upon completion, your license is reinstated. And if you fail the diversion, then your license continues to be suspended till the 90 days. And that's if the diversion, yeah, that depends on the timing of the diversion. The diversion takes.
Why not just say during the time of diversion, and then if you fail it, it's a plus 90 days? It's just gonna be 90 days. You don't have to do any of this adding or figuring out things. If you fail diversion, you got 90 days.
My response to that would be it wouldn't be really consistent with the way, like, when you have an automatic suspension in the adult DUI world, like that automatic suspension time is running against any like total statutory time of your suspension. Like you're even, because in those instances, you're not adjudicated yet. Like the state's like, we take your license away. It doesn't matter whether you're guilty or not. We're terrified of you being on the road, basically.
Well, I think we need to find out how long.
So that's the only reason
Then I think that's gonna create some sort of different expectation by everybody that gets one, how long diversion's gonna take. You know, and I was willing to do it the whole time, but it still took me 10 days longer than you. Yeah, you know, so I mean, it should be a set, to me, definitive number.
the length of the suspension.
Right. So that's me.
I would just echo that. I agree with that because I think that also puts pressure on the diversion of being like, you need to meet with me. We need to get this going. We need like, and if one diversion is quicker and yeah, I feel like that creates a mess and chaos.
Regardless of suspensions, what happens if you fail diversion?
It's a fine plus suspension.
So that's what, for me, I would see a smaller amount of the suspension that goes with the diversion piece of it. Because if they fail diversion, they're going to have a suspension anyways. And I think it's also thinking about what is our goal of this suspension? It is to give that timeout period. This is what I'm saying, like, okay, you made this really bad decision. You're going to have this timeout. You don't get it. But I feel like Marshall's point of we're in a very rural state and people depend on driving is so important that there is an impact not only, I know Ian has a question, that there's the impact on that person, but also their families not being able to have the other driver. And the fact that they're going through diversion, they're going to have that time for reflection and repair. I just think, what is the goal of having a longer one? Just to punish them? Well, that's where I'm stuck. I feel like.
I think it's in part to be consistent with if you get a moving violation of 3 points, then it's 90 days suspension. I think that's part of it, right?
Depending on if we go shorter than 6 months, whatever we end up with, they could be done with their suspension before diversion and still end up with another suspension.
Right.
So then they get double suspension.
Well, they get one suspension because the behavior, they go into diversion to deal with the behavior, but also you get grounded for whatever the time is. And if you fail diversion, your suspension, the consequence for failing diversion is you're gonna have further suspension. Because if you fail diversion, that means that you probably haven't straightened up as far as your act, and it becomes more, in my view, a safety issue as well.
Yeah, I kind of look at it as a minimum of 90 days just because of the moving violation thing. And to me, the driving under the influence is more serious, chances are more serious than a moving violation unless you drive 120 miles an hour maybe, but.
Right.
And I just think it warrants a little bit more incentive, I guess you could say.
I think a second motor vehicle violation, like more than doubles if you have one on a graduated license. So you would think that that next suspension could be pretty serious.
Yeah, second subsequent is a year.
Wow, it's a year. Okay, there you go.
Yeah, so Ian and then Ken.
Well, I think I would ask Karen, from your perspective, like, does from where I'm sitting on it, like, I think you have this opportunity with a younger driver to really instill how absolutely dangerous and like how you cannot drink and drive, right?
Mhm.
And that, like, I believe in the restorative justice element of it, but I can't imagine a 16-year-old who gets close at 1.03 and then they are able to drive the next day and they continue to drive. How that not suspending their license immediately to show them how absolutely serious it is that they did that, why that would not be an important part of.
Yeah,
And
I
like
agree with it. It's the duration of it.
Yeah.
I don't think 90 days. I think they will get that very clearly in a less amount of time.
and you think like, and 10 days is.
I do 10 days. I could go, I just think 90 days not having your license. If for somebody who, yes, made a very horrible decision, but in a rural state like Vermont,
Yeah.
you don't have your license for 90 days. Like, I'm just realizing with my oldest being able to have their license now, like, it has opened up so many doors for us as a family.
Yeah.
And so, and we're in Chittenden County. So if this was a family that was in rural Vermont, again, I'm not saying it's okay the decision that they made, but understanding they're teenagers making these decisions, right? That have some kind of timeout period, but 90 days is a lot to have them without their license when they're also going through programming to help them think about the impact of their actions and how they need to do the work to move forward.
Yeah.
Okay.
So going back to the diversion, I'm so confused. You failed diversion. How long do you lose your license for?
180 days.
6 months.
Also known as 6.
Thank you both.
We gotta help him out. He was confused a little bit.
Oh, you guys crack me up. Okay. So how can we what can we do better? I'm big on diversion. People screw up.
Yeah.
I really like diversion. Accountability. How can we enforce that better without, like, forcing them to do the contract without losing their license 6 months? 6 months is a long.
Right, they just have to finish the diversion, they don't lose it for 6 months, right?
Did you not hear what I said? I said, when they don't do their diversion, when they drop out of their diversion, how do we force them? How can we make this strong enough so they suffer a stronger consequence without losing their license for 6 months?
So,
What?
I mean, I think that the 90-day with the moving violation, I mean, you tie that to the fact that it's 180 days for an O2 ticket. But we have this different path because of we have better outcomes longer term with these individuals. But we do want to, definitely have consequence right away, an immediate suspension. So I don't think that has to be 90 days because that 180 days is still hanging over the individual as well. And we got them into the program. So, I think less than 90 days, 30 days, 45 days, not 10. I don't think that's enough to really send the message, but we can, that's kind of,
To me, 90 days is enough to send the message. April 26, 1976, I was 19 years old. I got a DUI. I lost my license for 90 days. It was a freaking joke.
In what sense? It wasn't big enough.
It meant nothing. I mean, I got my rides. I was living in Pittsfield.
What do you mean it was a joke? You still drove or you just got rides?
No, I got rides. I mean, I made do, but it wasn't a penalty. It's only 90 days. It went by like that.
I
Oh my God.
appreciate that. I just think that there's different situations or something. There's something like losing it for one day. That could be the game changer for it. And so for you, maybe we needed a longer one, but I don't feel like we should be passing the law to the extremes, but finding kind of a middle ground on it is where I'm at with it.
Yeah.
So I could go over 10 days. I just don't
You
see,
do it with a criminal moving violation or a moving violation. Why wouldn't you do it with a criminal thing like a DUI?
So,
Sorry.
well, but again, we have this different path to go through. In a moving violation, the moving violation, we don't have the path. But I mean, we have this different path.
Yeah, it goes 90, 180 or whatever. It doubles every violation that has points over 3. And then I think it doesn't take many and you lose your license until you're 18.
Yes.
Something I think I thought of last night is that makes the case, for me, makes the case for something longer, an immediate suspension and I don't know the duration, but longer than 10 days, I think, is that this person at this point has actually violated 2 laws and is only can only be, they have to choose, the prosecutor has to choose one. They're drinking under 21 and then drinking and driving. I know that they're not at 0.08, they're not at the legal limit, but I think that's still, for me, that helps me feel better about the immediate suspension, even while they're doing completing diversion. So the only question I have, and I guess this is what everyone's talking about, is the duration. And I would consider the fact that they're actually violating multiple laws.
So maybe we'll get some more testimony to help us convince either Karen or Tom to move off their position. Which is fine. To see if we can find the compromise that we can all agree to. So